as Martin has said, I think Section 18C of the Racial Discrimination Act is certainly, and freedom of speech more broadly, is certainly these are issues that fire people up. And I think certainly the way that the debate has played out over the last few months and the last few years over this issue in particular has been very interesting. It's both interesting in the content of the debate and to look at a more meta level about how these debates can play out. How they can achieve good things and bad things, and whether or not the way of approaching debate, and we've seen the way that the Attorney General's approached this debate, has perhaps not been the most helpful way of going about it. And it's interesting, I think, to reflect on whether or not you can achieve change in some ways, and whether or not you make things more difficult for yourself if you talk about people's right to be a bigot. I thought I'd just ask to do a straw poll around the room whether, if you know what Section 18C is, whether you could raise your hand if you agree that Section 18C should be repealed. I've got a lot of work to do. So, as many of you will know, on the 25th of March this year, the Attorney General, George Brandis, released an exposure draft, which was a draft piece of legislation which said, he talked about the repeal of Section 18C, but what he's done is amend Section 18C. He's changed it quite fundamentally, but Section 18C will remain, or there will be a provision that is similar to Section 18C that will remain. And to understand what Section 18C is, essentially it makes it unlawful to offend, insult, humiliate or intimidate another person on the grounds of race, colour, ethnicity or nationality. There are a range of exemptions that can apply in certain situations. There's exemptions for academic works and for scientific works and for fair comment, as there is under defamation law. But in all cases, those exemptions will only ever apply if your conduct has been reasonable and in good faith. The exposure draft makes several changes to the law as it currently stands. The most significant changes are the removal, and it's not quite as simple as a lot in the media have been talking about this, but essentially it's the removal of the first three words of that provision. The words offend, insult and humiliate. Those words are essentially replaced by a new word, vilify, and the word intimidate has been left in the new provision, or it is at least under the exposure draft, but it's been defined. It's not currently defined in the law, it's not defined in the legislation, although of course in interpreting legislation, judges have defined it. I think probably the most important change though that's been made here has really nothing to do with the substantive aspects of the law. It's really got not a lot to do with whether or not we use the words vilify or hatred or threats or intimidation. The much bigger change, I think, is the very broad exemption that's been included under the exposure draft. So the Section 18C exemption, as I said, only applied in very limited circumstances. That exemption now has been broadened, and broadened in a pretty significant way. It's now going to be, your conduct will now be exempt, even if you have vilified or intimidated someone on the basis of their race. These exemptions will apply in cases where you are discussing social, political, economic issues, and there's no requirement for reasonableness or good faith. A lot of people have said that this is the point at which the exposure draft goes too far, but I actually think that it's a really important thing that we have this exemption in there, and a part of the reason I think that's important is because of the case that has brought these changes about. The impetus for change, really, I mean, this law has been around since 1995. It was, most people didn't really know about it. I mean, there are a few obscure articles that were written by free market think tanks like the Institute of Public Affairs, but for the most part, people weren't talking about Section 18C of the Racial Discrimination Act. But on the 28th of September 2011, a journalist and a quite divisive journalist was taken to court under these provisions and was found guilty of breaching the provision, or was found to have breached Section 18C. And I think that really, for a lot of people, that brought Section 18C into the public debate. It would have, you know, if we were talking about a provision that was used against Holocaust deniers and against people who said racist things at airports and that kind of thing, no one would have cared about Section 18C. They would have thought it was doing a pretty good job, and certainly there would have been no impetus for repealing Section 18C, but after the 28th of September 2011, I think all of that changed, and it was very quick that the debate picked up around this. On the 30th of September in that year, the then Shadow Legal Affairs spokesman, George Brandis, wrote an op-ed, and at the end of that op-ed he said that Section 18C should be repealed, at least in its current form. We didn't really know what that meant, and the same sorts of words were used in a number of speeches by both Brandis and Abbott in the preceding in the following years. And then in government, we've got a situation where the government has now proposed this exposure draft. I think the basis of these changes is one where people mostly, I think, don't accept that journalists should be censored. There's a question about on what grounds journalists might be censored, but we are talking about a situation of censorship, and I think a lot of people say, well, once we're at the point of saying journalists can't say certain things in newspaper columns, we've reached a point where the law might have overreached. The problem, of course, is that in using Bolt as the impetus for change, we're using a figure who, rather than the principle of freedom of speech, creates division on the content of what he's talking about. People have feelings about Bolt. They either like him or they don't like him, and those feelings can often be pretty strong. But it's been good to see, and it has been good to see after that case, a number of people who disagree with Bolt on the content of what he has to say, but agree with the principle of freedom of speech and agree that Section 18C does go too far in censoring journalists. People like David Marr, and a respected journalist who at the time was writing for The Age, said that Section 18C goes too far. Sarah Joseph from the Caston Centre for Human Rights said that at least the words offended insult should go, and there was a question about humiliate. Jonathan Holmes also said that the laws go too far. The Age and the Saturday Age wrote editorials saying that we shouldn't we shouldn't accept laws that restrict journalists' ability to write articles. There was a very interesting poll that came out. I'll talk about two polls. One of them was if given the choice between the right to freedom of speech and on the one hand and the right not to be offended on the other, which would you choose? And perhaps unsurprisingly, 82% said the right to freedom of speech was more important. And that poll was done in 2011. We saw earlier this year another poll was done. Should it be unlawful to offend, insult and humiliate someone on the basis of their race? 88% said yes, it should be unlawful. Now, I think a lot of people would look at those two polls and say, well, either there's been a significant change in the way that people feel about these issues in Australia, or you've got to dig a little bit deeper to find out what the meaning of these poll results are. And I think you do have to dig a bit deeper, and I think it says something that is very clear, and I think it says a great thing about the way that Australians feel about these issues, and that is that they don't accept that people should be offended or insulted or humiliated on the basis of their race. I think it says something very positive about Australians' attitudes towards racism and towards tolerance and diversity and multiculturalism. And I'm not surprised by these results. I think for the most part, we do accept that it is unacceptable. But then the question is whether or not those things can be regulated in either legal or social ways. Certainly my view and the view of people who are in favour of repealing Section 18C or significantly amending Section 18C is that a far greater control over these things is a social control. It's far more effective. We've seen over a long period of time Australians' attitudes towards people of ethnic minorities changing and changing for the better. And there's no reason to think that Section 18C of the Racial Discrimination Act had anything to do with that. Certainly, if you look at the kinds of policies and the kinds of attitudes that people had in the 40s and 50s compared to the sorts of attitudes that people have today, I think it's a great journey that Australians have gone on. It's a great journey of tolerance, and there's nothing to say that Section 18C, which was introduced in 1995, has had anything to do with those changing attitudes. If anything, Section 18C probably followed the change in attitudes that were happening already at the time. We've seen a couple of issues after Section 18C, which it's important to point out Section 18C wasn't able to stop. But certainly I think overall the message is one of, is a positive message. I think it's important to point out a few things about Section 18C, and one of them is that even the Australian delegation to the United Nations, long before Section 18C was being considered in 1995, when the negotiations were happening around the treaty that gave rise to the Racial Discrimination Act in 1975, there was a lot of talk about whether or not racial discrimination was actually something that could be remedied. There was a broad agreement that it should be remedied, but whether it could be remedied by law. And the Australian delegation to the United Nations at that time recognised that people can't be legislated into morality. Their view was very clearly that, yes, this problem is one that should be fixed, it should be one that should be solved, and it's a problem that we should turn our minds to, but it was one that we as private individuals should turn our minds to rather than the United Nations or governments. We recognised at that time that there wasn't much that we could do about it through the courts. You can't change people's minds by suing them. The United States has recognised this, and certainly the United States has recognised for a long period of time the importance of freedom of speech and has rejected time and time again hate speech laws that have been proposed by various states. They've been struck down under the First Amendment, which says that Congress shall make no laws that restrict freedom of speech. Hate speech laws have clearly fallen into the category of laws that do restrict freedom of speech, and they've therefore been struck down. But other countries in the Anglosphere haven't gone down that path. Australia obviously we have our own hate speech laws, and Canada until quite recently had its own hate speech laws as well. But Canada went down the similar path to the path that Australia is now going on, and it repealed at least a portion of its hate speech laws in a similar way to the way that's being considered under the exposure draft towards the end of June last year. There are two things that I'd like to say about hate speech laws and the limits to freedom of speech in a more general sense. First of all, I think it's important to recognise that there are limits to freedom of speech. I think that Martin has pointed out that the limits to speech are really all that we're debating here. There's a broad agreement that freedom of speech is an important principle. We recognise it's a cornerstone of liberal democracy, but where should those limits be? For a classical liberal like myself, the limits are at the point at which speech becomes action, or it's about to turn into action, and often we talk about that in the law as being incitement to violence. Very interestingly, that incitement to violence as a concept has been changed to incitement to hatred. Now, I think incitement to violence and incitement to hatred are two very different things. Just because we use the word incitement doesn't mean that we're talking about the same thing. Violence and hatred are two things in different categories rather than being on a continuum. And I think there's a broad acceptance that threats of physical violence, I mean, there are some, I've read some anarchists, Murray Rothbard disagrees on this point, that all freedom of speech should be allowed and that there should be no restrictions on freedom of speech, but threats of physical violence, incitement to violence and serious intimidation should be restricted. But that where we're talking about offending or insulting or humiliating, as Section 18C does, that there are legitimate cases for that kind of conduct to take place. I'm sure we've all been a part of a public debate where we've either ourselves been humiliated or we've humiliated others for saying things that are stupid. I mean, it happens all the time, and I think it should happen. I mean, there's no reason why we shouldn't humiliate people that say clearly absurd things in the debate. And I think in the matters that are debated and discussed under Section 18C and some of the cases that go to the court, they provide great examples of where this should happen. Holocaust deniers, for instance, I think should be humiliated. I think there's a good case for humiliation as being quite an effective tool, and not offending someone or not humiliating or insulting someone on the grounds that it's not the kind of conduct that we want to see in the public debate, I don't think quite goes far enough. I think often it's important to engage in that kind of very lively debate, and often that's the only effective response to absurd things that are discussed in debates. In a very important way too, hate speech laws are actually counterproductive, and I'll explain why that is. we often see the law, and particularly lawyers see the law as being a very finely tuned instrument, and we think that we can change a few dials here and there and we can get different results, and by changing those dials, even at the margins, we'll get the results that we want. Often I don't think that that is the case, and certainly when it comes to hate speech laws, there's a very good case for recognising that hate speech laws do catch people who offend, insult and humiliate. But what kinds of conduct do they catch when they catch those sorts of people? I think it seems very clear, and if you look at the almost 100 cases that have been considered by the courts under Section 18C, it's very clear that they catch obvious cases of racism. They obviously catch the woman in a court who called a security guard a Singaporean prick. That is very obviously racist. It was very obviously a breach of Section 18C, and it was caught by Section 18C, and the woman in that case was fined. What it doesn't catch is the people who use those same arguments but are able to use very sophisticated language to discuss these issues. And I think there's a real problem here. Hate speech laws, in a very real way, teach people to use sophisticated language, to get rid of the signifiers that allow most of us as an audience to say what that person is saying is racist and unacceptable, and instead use a veil of sophistication to convince a much broader audience than they would usually have if those signifiers were there. Without Section 18C, I think for the most part you would have, I mean obviously there are always going to be sophisticated arguments about racist ideas. Those are always going to exist. But certainly hate speech laws teach people to move in that direction, and I think there's a bias in hate speech laws more broadly, but certainly badly drafted laws like Section 18C, which say that, well, if I want to get my ideas across to a broader audience, I've actually got to use really complicated language. And in doing so, I think you open up a much broader audience than you would otherwise have if you were using the kinds of things that woman did in the court. I want to finish on a point that's been raised a lot throughout this debate, and it's concerning to me on a number of levels, but I think it goes to the heart of what we believe about human nature, what we think about our fellow citizens here in Australia, and whether or not we can actually trust the democratic process. Tim Soutphommasane, the Racial Discrimination Commissioner from the Australian Human Rights Commission, has said in a speech to the ANU, the Alice Tay lecture this year, that repealing Section 18C could unleash a darker, even violent side of our humanity. Now, there are two very important things to say about this. One, I think it reveals that Tim doesn't think much of his fellow citizens. If he thinks that it's only the state that is stopping people from expressing the kinds of views that he doesn't want to see in the debate, and from going even further than that and unleashing a violent side of humanity, then I think we have much bigger problems on our hands, because the relationship between the citizen and the state is not such that the state should be telling citizens what to do. It in fact gets that relationship completely the wrong way around. The state should always be controlled, and our politicians and bureaucrats and commissioners like Tim Soutphommasane should always be controlled by a free citizenry. It should be up to us to decide what governments should do. It's not up to governments to tell us what to do. And certainly I think it reveals a problem for democracy. I mean, if we don't think that without laws like this, we can trust people to make the right decision, we can trust people to reject racist ideas, then what does that say about the democratic process? How can we possibly trust people to make the very complex decisions that they're asked to make at elections if they're not rational individuals? I think there's a way through here, and I think the way through is to recognise that social opprobrium is a much, much more effective way of combating racism than the law ever will be. As lawyers, we often think that we're in a pretty good position, and we think that we are able to use the law to shape society in a particular way, and I think we're wrong. I don't think that we can do that, and there are lots of examples to show where social opprobrium works much better than the laws do. A very simple example that I was talking about on radio the other day was none of us walk down the street naked, or very few. I mean, it's pretty rare that you see someone walking down the street naked. And I'd suggest that the reason why you don't see people walking down the street has nothing to do with indecency laws. I mean, there might be people who might argue, no, it is indecency laws that stop people from doing that. But I think the much stronger case is one of embarrassment. I mean, you know, you're going to be embarrassed to walk down the street naked. You know, other people are going to point and laugh at you. And I think that's precisely the tool that we should be using to combat the kinds of attitudes, the kinds of behaviours that we don't want to see in society. Those have always been the more effective ways of regulating conduct. And certainly when it comes to racism, I think it's more effective. It's more important for us as individuals to take responsibility and to say to people when they do talk about racist ideas, when they do engage in racism on public transport has been a hotbed of this kind of thing recently. It's important that we feel empowered to say to these people what you're doing is wrong, rather than saying, well, I'm going to make a call to the police, I'm going to make a call to the Human Rights Commission, I'm going to go to a judge and I'm going to engage a lawyer. I think it's more important that we socially regulate than legally regulate these things.